Inherently one-sided and shrouded in secrecy, grand juries often listen to weeks of testimony from prosecution witnesses only, who are not cross-examined, and in most states, the proceeding must remain completely under wraps. In the end, the panel almost always decides to charge the defendant, with one major exception, when the case involves a police officer. As you know, in the past 2 weeks, grand juries in Missouri and New York have declined to indict white police officers responsible for the deaths of unarmed black men, sparking ongoing protests across the country. The Justice Department is now investigating both cases, but some believe that's only necessary because the grand jury system is broken. That's the argument laid out in a Boston Globe op-ed this weekend that reads, "The best possible reform that can come from these complex tragedies is to get rid of grand juries for everyone." I'm joined now by the author of that piece. Carrie Hong is a criminal law expert and a professor at Boston College Law School. And also joining us is criminal defense attorney David Yannetti, who has served as lead counsel in 12 murder cases. Welcome to both of you.
Thank you.
All right, Carrie, take it away. And I was looking at the history here of grand juries, and the irony being that they were established to kind of protect the citizen against the government, as the big accuser, and that's kind of turned around on us.
Yes, historically they're justified, and even contemporary, the secrecy is justified by the Supreme Court because they're supposed to be a shield for the citizen against the state. In reality, though, there's an alternative that exists. Half of the states do not have grand juries. Half the states have preliminary hearings that provide more protection to the defendants than are present in the grand juries. And unlike what we're seeing in Ferguson and New York, the grand jury is shielding the prosecutor from controversial decisions.
For the average citizen, give us the difference, because many times people are accused, they bypass the grand jury system. Not every person accused of murder is indicted by a grand jury, right? Or are they?
They are. They have the right. They have the right to waive an indictment if they want to, on the federal level. But they all have to. There has to be probable cause. The confusing part, probable cause, is exceedingly low, which is why statistically it's 99.993% of all cases that go before the grand jury result in an indictment.
I see.
So the question is, if there's an existing alternative, why not explore that?
What do you think? Should we get rid of this?
I don't think so. I was a prosecutor for 10 years before I started my own criminal defense practice, and I put a lot of cases into the grand jury. And there are other functions to the grand jury beyond merely indicting people. Prosecutors can use them as an investigatory tool. And I know this is something that I did when I was a prosecutor, where for instance, you're conducting a murder investigation and you want people to talk to you. They say no. You can't compel them to talk unless you send them a subpoena, bring them to the grand jury, and then sometimes that's how you flush out a case and investigate a case.
Okay, here's something though. A grand jury can't indict unless a prosecutor signs off on it. Well, what's the point of that? If 12 people think that you should be indicted for something, and the prosecutor says, no, which could very well have happened in these police officers' cases, that the prosecutor says, no, forget it. Well, then what's the value of having it?
Well, I don't know what's happened in these specific cases in terms of the vote.
Well, I think we know one was 3 and 9.
Right. Well, it is a very low standard, and if they can't get over that standard in the grand jury, where in Massachusetts, for instance, there are 23 grand jurors, 12 of them have to say that there's probable cause. If you can't convince 12 people that there's probable cause for a crime, what are your chances of bringing a case beyond a reasonable doubt at a later juncture?
But the difference is grand juries do not have to be given the law.
Right.
They do not have to be instructed properly. They do not have to be instructed at all. And so with that respect, can be manipulated by the prosecution.
It is manipulated by the prosecution.
It
totally.
is. And furthermore, the justification that's used is that because it's a sword, it helps the prosecution. But the secrecy is justified in the law because it's supposed to be a shield for the citizens. So if we're going to live in a society where the prosecution gets more tools, call it what it is, but don't say that that's because of the rights that are guaranteed to individuals.
So you're saying in other states they just have what is called a preliminary hearing, and do both the prosecution and the defense have an opportunity to present evidence?
They do, but as a practical matter, and the probable cause precedent is still there, but the difference is it's recorded, the defendant gets to see everything, the defendant is present for everything, and there's an appellate process, so it saves judicial resources in that if a prosecutor forgets to prove an element of the case, it can be dismissed right away. If it's a novel legal theory that's applied to a new situation, there can be a legal appeal saving thousands of dollars and thousands of hours on trial preparation. So it saves money down the line.
Shouldn't these proceedings be at least audio recorded? I mean, if you want to identify, you want to protect the identity of the jurors, but shouldn't we have access to listen to what some of these cases were presented?
You've just asked two questions. Okay. They are audio recorded in Massachusetts. So there is a record, but the question is of access. That only comes into play if there's an actual indictment. So, for instance, if the grand jury does an investigation, everybody is recorded there. There's a court reporter right in the room with the grand jury. There's a transcript that is produced, but that transcript is only made available to defense counsel if there is a defense counsel. If somebody is not charged with a crime, then there's no turnover of the grand jury transcript.
In Massachusetts, it's unique that it has protection. A lot of states do not have that basic protection of being recorded.
It makes sense to me that they should be recorded, no doubt.
And what about just the whole privacy aspect of it? I mean, jurors on most cases have the option of speaking publicly afterwards, the media, whoever, but as I understand, the grand jury is not allowed to?
Right. It's a secret proceeding.
Well, who says? If I'm on a grand jury and I want to speak, well, why can't I? What's going to happen to me?
Well, you could be charged with a crime. You could be hindering an investigation. You could potentially be charged
after the fact.
Well, it depends. If an indictment has issued, then frankly I don't know the answer to that. But if an indictment has not issued, then it's still a secret proceeding.
But significant, you can make a vote without having heard all the evidence. If you were gone for 3 of the 4 days that the prosecution was presenting, you're still allowed to vote. So this is not...
Yeah, that's not supposed to be the case, but I agree. There's playing fast and loose really leads to some bad results.
All right, David Yannetti, thanks so much. Hong, thank you.
Thank you.